Thank you all for joining us for today's session. My name is Mark LaFleur with Wirewheel, and I'll be emceeing this discussion. Before I introduce our speakers, I'd like to cover off just a few housekeeping items. As I mentioned, you should all see a brief poll question on your screen. You can please go ahead and submit an answer if you'd like. Please also note that the views expressed here today by our speakers are their own and not the views of their organizations. And last but not least, we hope that these sessions will continue to be interactive. So please submit questions via the Q&A button on the bottom of your Zoom screen. And as an additional incentive, the first 5 participants to submit a question will send a free Spokes t-shirt. We are very excited to have a fantastic lineup of experts here for you today in this session. Jeremy Bash is the founder and managing director of Beacon Global Strategies, LLC, and the former chief of staff at the CIA and the Department of Defense. Robert Litt is of counsel at Morrison & Foerster, LLP, and former general counsel for the Office of the Director of National Intelligence. And Glenn Gerstel is a senior advisor at the Center for Strategic and International Studies and former general counsel for the NSA. And moderating today's session is Charlie Savage. Charlie is a Pulitzer Prize winning journalist and the Washington correspondent for the New York Times. Delighted to welcome you, Charlie, and the rest of the panelists. Charlie, please take it away, and I'll be back at the end of the session to help wrap up.
All right. Well, thanks for coming to our session as well in this virtual environment. We're going to be talking about national security issues and surveillance, data collection, privacy, and how those issues run through some of the topics that this conference has been dwelling on. And as you just heard, we have an unusually excellent panel of former government official experts to talk through some of the most interesting issues of the day raised by this topic. To get us going, I'm going to ask Jeremy if you could describe the national security landscape briefly against which the new tech issues we're about to start talking about will be playing out.
Thanks, Charlie, and great to be with Glenn and Bob, and thank you to Mark and Justin. Charlie, I think first from the U.S. government perspective, or I should say from the U.S. national security establishment perspective, we are in an era of great power competition. And great power competition is really now the new dominant paradigm that runs through the new national security strategy and the new national defense strategy. And what that really means is that the U.S. is contending with the rise of near-peer competitors, principally China and China and Russia, and while keeping an eye on some of the enduring threats from Iran, North Korea, and extremist terrorist organizations. Of course, over the last several months, there's also been a lot of discussion about expanding the definition of national security to encompass some things that the intelligence community has been warning about for many years, including the problems we now see with the rise of a global pandemic. But coming back to the essence of the paradigm, the new paradigm, is it's really a shift for the United States away from the post 9/11 war years, where we were principally focused on disrupting terrorist networks and denying them safe haven, to focus again on the rise of China and the rise of Russia. From the perspective of technology, Charlie, and as we think about the interplay between technology and national security, I would begin, I guess, by highlighting 4 trend lines that I will throw out there, and we can discuss them throughout the hour, that I think are relevant for our understanding the interplay between technology and national security. The first is clearly tethered to the paradigm I just referenced, which is China's ascendance in technology and its use of technological advancement as an asymmetric threat to the US, our interests, and our values. And in particular, if you analyze China's civil military fusion policy, its Made in China 2025 policy, its One Belt, One Road initiative, all of these things, when you kind of pull them together, they paint a picture of China wanting to be more self-reliant for itself on technology, and wanting to export that technology as a foreign policy tool to impose their model, whether it's digital authoritarianism or other models, both for commercial and geopolitical advantage. So number one, China's ascendance. Number two is the fragmentation, I would argue, of the information environment, which of course we all understand intuitively that you don't get all your news from one place anymore, or even a handful of places like your hometown paper or the evening news broadcast, But the information landscape is so fragmented with so many blogs, so many social media outlets, so many websites, so many online resources, and the proliferation of niche publications and niche networks even, that this is a fragmentation that has a lot of implications for national security, because in part, it provides a forum for a lot of mischief, a lot of malfeasance by state actors willing to leverage that fragmented media landscape. And we saw that clearly in the 2016 election, and I would argue we're going to continue to see it in the 2020 election. Third, Charlie, I would say, is the rise and ubiquity of app-based communication, or what some people call the great unplugging. And we're using one of those apps today. We're using an app for our communication, a one-to-many communication platform. And if you look at the way people communicate today with each other, with groups, with organizations, at work, in their personal life, for the most part, they're not relying on the old telecommunications infrastructure that many of us grew up with, where there was Ma Bell, and essentially we're using the telephony networks to communicate. Now, today, most of these are through apps, and it's a very decentralized process, and that has implications for law enforcement and implications for national security agencies that need and want access to communications to protect national security interests. And fourth, Charlie, an important vector for the interplay between technology and national security, I would say, is the advancement of autonomous systems. And when I say autonomous systems, of course, we've been tracking for many years the rise of unmanned aerial systems, drones, but there's a big play and a big push now within the Defense Department, the intelligence community, and other national security components of our government to develop human-machine teaming and utilizing automated systems, even beyond just person-controlled systems, but to go into artificial intelligence, machine learning systems. And those systems obviously trigger a number of critical questions about the rules of engagement, about the inputs to the algorithms that form AI and ML and other autonomous systems, and what should be the policy and legal landscape that should define how national security departments and agencies both use those offensively as well as use those defensively. So all of these issues really, I think, for national security practitioners like those on this panel, are at the forefront of our mind. And I would submit they kind of form somewhat of a basis for conversation these days about the interplay between national security and technology.
That's great. I'm going to return to you in a minute, but let's start diving into some of the technology and privacy and national security issues that are being affected by the factors you just described. I'm going to turn now to Bob Litt and move into the world of Fisa, the Foreign Intelligence Surveillance Act. Been much in the news lately, both because of the Trump-Russia investigation and the Justice Department's Inspector General report's findings about Fisa and the Carter Page issue, and because Congress is trying to pass a bill to extend some expired provisions of Fisa and running into some trouble doing so. Bob, if we could get past or put aside for a moment the political issues raised by the Trump-Russia investigation, can you help this audience work through some of the difficulties raised by Fisa and the problems that the Inspector General uncovered in applications in general, not just in the Carter Page matter, and what's in play now in this crucial issue?
Yeah, thanks, Charlie. So FISA, the Foreign Intelligence Surveillance Act, is one of the most important capabilities that our intelligence community has. A remarkable but unfortunately classified percentage of intelligence reports are based on information derived from FISA. What's happened in the last year, in significant part because of the Russia investigation, is that the issue of the scope of FISA, which has long been an object of discussion between the civil liberties community and the national security community, has become politicized in a way that I think is very dangerous. It helps to back up a little bit and understand what FISA is. There are really two big baskets of FISA. One is what's called traditional FISA. This is what the Carter Page FISA was all about. It's a provision that allows the government to go to a special court and get a warrant to conduct electronic surveillance on someone based on the court's finding of probable cause that that person is an agent of a foreign power, such as a spy. And the legal framework for that is pretty well accepted and not overly controversial. The much more controversial part of FISA is the other basket, which allows for very extensive surveillance of people outside of the United States, not necessarily based on individual findings of probable cause. I'll come back to that. The Inspector General's findings first about the Carter Page application and then about the other applications were all focused on traditional FISA. And what they found was essentially that the FBI hid information from the Department of Justice and the FISA court that might have been relevant to the court's determination of probable cause. It was basically much more of an FBI problem than a FISA problem. The problem with FISA was that because it's classified, there's no opposition to the government's application and there's rarely any judicial review. So there was no ability to self-correct what the FBI was doing. And this led, as everybody knows, to an ongoing tweet storm criticizing the use of FISA in the Russia investigation. This came up in the context of reauthorization of some provisions of FISA. FISA was expanded significantly after 9/11, but Congress made many of the provisions have a sunset date, so they have to be reauthorized. And at the end of last year, there were 3 provisions coming up for reauthorization. The 3 provisions themselves, at this point, were pretty non-controversial. Two of them were entirely non-controversial, and one of them, which was a provision that allowed the FBI to go to the FISA court for an order to get business records, had been the subject of controversy because of its use in a controversial NSA program that I'm sure Glenn will be willing to take the heat for. But that program, everybody agreed it was time to stop that. And so those 3 particular provisions themselves were not particularly controversial. The problem was that partly because of Trump's views and partly because of a coalition of civil libertarians on the left and libertarians on the right, there was a movement to have broader reforms to FISA going beyond these particular provisions. And this essentially led to a standoff in Congress so that the provisions expired and it's not clear now how it's going to move forward. What's interesting is that the basis for the standoff is an interesting issue that I think focuses on the interaction of new technology and national security. Senators Wyden and Daines proposed an amendment that would prohibit the government from using FISA to get somebody's internet browsing history without a warrant. You couldn't use this business records provision. You had to get a warrant. The Justice Department is strongly opposed to this. And here's what the issue is. Traditionally in the Fourth Amendment, when you're talking about communications, there's been a line drawn between the content of communications and metadata or information about the communication. If you think about, if you're old enough to remember when you used to get a telephone bill with itemized long distance calls on it, the information on the telephone bill was the metadata. It was the number that was being called and the length of the call and so on and so forth. And the government needed a warrant to get the content of communications, but not to get the metadata. What's happened is, in the context of internet searches, the line between content and metadata has been blurred. So to give an example, if you type into your web browser www.google.com, that looks kind of like a telephone number. You're going to the Google website. But if you type into a search bar, how do I cure venereal disease? That also comes up in the URL you're searching. And that kind of looks a lot more like content. And so this has created a standoff because the government doesn't want to have its ability to get this information limited. And the civil libertarians think you're invading people's privacy.
And let me jump in here quickly with a follow-up, because these kind of surveillance and tech questions can be very abstract, but you're starting to drill in on something very concrete. And in this area of what has stalled this bill out, I think there's another specific application of this power that has maybe always kind of lurked in the background for people who are nerds for this stuff, but is now kind of emerging more clearly into daylight because of the argument that's been happening in the Senate and the House. And that is that sometimes the government isn't trying to investigate an individual in the sense of what is Bob Litt typing into his search bar when he logs on this morning, but rather they're looking at destinations to see who comes there. They might put an order not to Google for Bob's stuff, but for all people who type in, how do you build a bomb? Or they might go to YouTube and say, we want all people who have visited this Anwar al-Awlaki, radical Muslim incitement sermon and see who's interested in this stuff, so that there is not individualized suspicion until someone has gone on the internet to explore their curiosity about something. And it seems to be something that the FBI uses as sort of an early warning system, but is exactly the kind of thing that Senators Wyden and others are concerned about in terms of freedom and privacy on the internet. Do you think the government should be able to basically hang out outside the door of those buildings and keep track of everyone who chooses to come into them?
Well, Charlie, you stole my analogy there, because from the government's perspective, this is the modern high-tech equivalent of having an FBI agent sitting outside the Mafia Social Club and looking who goes in and out there. But as you noted, it's quite different in one respect, which is that somebody going in and out of the Mafia Social Club has a pretty good understanding that the FBI may well be sitting there watching it. Somebody who is going around on the internet doesn't necessarily expect that they're going to be watched in the same sense, and so there's a higher privacy expectation. On the other hand, if you think of the website that Anwar al-Awlaki, the Al Qaeda in Yemen activist, was maintaining, and it was directed at Americans to radicalize them to commit terrorist acts. There's sort of a legitimate government interest in knowing, are there any Americans who are going to this website who are potential targets of radicalization? My own personal view is that we are going to have to do some rethinking of basic Fourth Amendment law, and maybe focus more on what the government does with the information and what information it collects. Give the government the opportunity to find out who's visiting these websites, but then don't let them do anything with that information unless they have a stronger individualized suspicion than they otherwise have.
And I would just flag, we don't have a privacy activist on this panel. I'm sure that if someone from EPIC or the ACLU or EFF was sitting here, their heads would explode at that prospect. They would say, you can't trust the government. Of course they would abuse that, and people need to have the sense of freedom that they can go on the internet without being tracked just because they visited the wrong website, kind of thing.
Yeah, I've had that discussion with them many times.
Mm-hmm. All right, well, I wanted to get Glenn involved here. Glenn, you left the NSA very recently and were there as the program that Bob referenced a minute ago that was basically in various forms since right after 9/11, giving the government access to bulk records of Americans calling record logs, not what they were saying to each other, but who was calling whom and when and how long the call lasted, collapsed and was abandoned by the NSA, and is now, if and when Congress ever gets its act together, the legal authority for it will be removed from the statute books as well. Can you lay out for us the rise and fall of that activity? What was the dream? What was the point of having the government be able to see all these social connections between people? How did it actually work, and why did this program get shut down?
Good, Charlie, thank you. And first, let me say thank you to you, and it's great to be on the panel with my other colleagues here. Very, very much appreciate it. So the CDR program that you're referencing.
CDR meaning call detail records.
I was just going to say the call detail record program that you're referencing was one that NSA operated and then ultimately suspended, as you said, after a number of years. And it's really a great example, a case study, if you will, of how a well-intentioned scheme needs to be thoughtfully crafted, and when it's not, it can go awry and not produce the results we want. So let's start with the sort of the why and history of the program, talk a little bit about how it operated, and then what are the lessons learned. As to the why, it was pretty simple. After 9/11, there was a suggestion that if we had only been able to track the overseas terrorists who were talking to some of their counterparts, their co-conspirators in the United States, and make that connection, we might have been able to avoid the 9/11 attack. As a result of that, under the Bush administration, there was started a rather significant telephone surveillance program to understand who was calling whom, what connections there were with overseas terrorists. This turned into the USA Patriot Act. And then that was revealed famously in the summer of 2013 by Edward Snowden, who caused a great furor by disclosing the extent and scope of the program, even though it was legal. As a result, Congress completely revamped the program. It's something called the USA Freedom Act in 2015, which coincidentally was about when I joined the NSA. And the program in its simplest forms represented a significant change, with the government not holding the data about the phone calls, but the phone companies kept their own billing records, their own customer records. And the way it worked in very simple terms was where NSA or the FBI had a specific indication that a terrorist was using a particular phone number, they'd submit that phone number to the phone company and say, tell us who else this person has been in touch with in the United States. I'm glossing over the details. They were allowed to do that to a limited extent. And that produced not the content of the phone calls, not the location of the phone calls, not any financial information, just who the phone number A was talking to phone number B. As you might expect, while that was of some utility, it wasn't of much utility. And it turned out that the program cost about $100 million over a few years, led to 15 intelligence reports being produced, of which only 2 the FBI said were of any real value. So from a cost-benefit point of view, clearly was not worth it. In addition, and the real problem was, and I personally was involved in this, it turned out that the records we were receiving from the phone companies were incorrect, not because of any error by the phone companies, but just because of the mismatch between what the statute required and what the phone companies were able to produce with their own billing records. So as a result, NSA was in the position where it was receiving information that it wasn't authorized to have under the statute. The decision was very clear for us. We shut the program down. And as you've alluded to and Bob has alluded to before, the result of that is that the program is now suspended and Congress will not reauthorize it. So I think there are 2 lessons that come out of this. There are many lessons, but 2 in particular for me. One, it's that a program that is constructed and designed and based on a specific technology where the safeguards are built into that particular technology is almost doomed from the beginning because technology evolves so quickly. Why? Well, the obvious answer is terrorists are not using voice phone calls anymore. They're using encrypted applications on the web, Telegram, Signal, WhatsApp, Instagram, you name it. That's how people are communicating, not by voice. The technology is outdated. And secondly, I think it's a mistake to erect an entire integrated intelligence program, in this case, one aimed at counterterrorism, on private sector data. Private sector data is designed for commercial purposes, to assist customers, to assist companies in their billing, et cetera. It's not intended to be an intelligence goldmine that one searches through. That isn't to say that private sector data isn't important, and it's going to become increasingly important, which is of course what this conference is about. But erecting an entire program just simply on looking at private sector and that's the architecture, private sector data on that, that's the architecture, I think is a mistake. We need to figure out how we should use the increasingly important private sector data in a way that's meaningful to supplement intelligence activities.
I imagine that a piece of that is the attempt to use private sector data subject to a set of rules and limitations and constraints imposed by statute and by court is a difficult task when you're relying on outsiders to obey those rules as well. You can get the agency in trouble even if it's obeying the rules. And of course, the NSA has also had trouble in obeying those rules over the years too, because of technician issues, interacting with lawyers, not always seeing eye to eye on what they're supposed to be doing. It's just it seems to be a can of worms.
Yeah, absolutely. So when you have a statute that imposes all these rules, which I'm not in any way complaining about, don't get me wrong, I certainly understand the need for these restrictions, but where the restrictions are baked into a statute, where the statute understandably gives no tolerance for error. It's not as though the NSA is told in a statute you can have 5% errors. You're supposed to have 0% errors, and we get that. That's exactly right. I'm not questioning that for a moment. But where we have technology enshrined in a particular statute, it's very hard to comply with that and monitor it. I might add that all the studies, and you've alluded to this too, Charlie, all the studies that have been done of this program showed absolutely no willful abuse, no partisan use of this program at all. But there were technical complications. You're absolutely right.
All right, let me turn back to Jeremy here. Glenn was just mentioning how terrorists don't use conventional phone calls anymore. None of us do as much as we used to. But the communications have migrated towards encrypted apps like Signal, WhatsApp, Telegram, not just for the bad guys, but for all of us. And in the area of after the 2016 election, we also see increasing awareness and concern about even state actors who are capable of hacking into private communications. With the result being that everyone is using encrypted apps, but the government, law enforcement, and intelligence agencies, particularly the FBI, is increasingly concerned that where they used to be able to go to a judge and get a wiretap order and go to AT&T and implement that, they are now going to the judge, getting a wiretap order, and then coming to find out that their target is using an app that does not let them carry out the authority they think they have, or they do have the legal authority to do, just as a practical matter. And so we've seen a rise of a debate sometimes called going dark, in which law enforcement officials in Democratic and Republican administrations are expressing worry about this, and they want Congress to pass a law mandating essentially the building of backdoors into commercial encrypted communication systems so that when they get an iPhone, they can get into that iPhone. If they get a wiretap order, they can spy on the person who's communicating over a wire the way they used to be able to more freely. Can you walk us through the debate and the dilemma that these encryption debates are raising, and including the notion that it's not just terrorists and child pornographers who might use encryption, but also malicious hackers, including Russian and Chinese state-sponsored ones?
Yeah, Charlie, look, I think the law enforcement perspective is well-founded. I understand the frustration that law enforcement leaders have long been grappling with because of the phenomenology that I mentioned, and you also referenced, which is the ubiquity of encrypted app-based communications. And if law enforcement is expected, and we rely on them to do their job of keeping our country safe, they have to have capabilities, and they can't sort of lose yardage just because the technology outpaces the legal authorities. But I have to say, by the way, I've always listened carefully to the Going Dark presentations by Bureau and other officials. And again, I think at a high level, I'm empathetic to the concept that we've never had a legal regime in our country where there was a place, a safe, literally a combination safe, that law enforcement could not get into to find illegality or threats to national security. I get that. But I have to say, as I've listened to the remedies, the cures for this disease, almost all the cures seem worse than the disease itself. And I've yet to see what I would regard as a workable solution whereby it's legally mandated that a private sector company maintain a key to decrypt the app-based communications for the purposes of a law enforcement warrant. I think there are a number of problems with that. First, and I think most centrally, is that introduces a major cybersecurity vulnerability to encryption, generally speaking. And so it's not even just a contest between security and privacy. It's actually a contest between security and security. The security of communications on one hand, the law enforcement requirement to have security on one hand and cybersecurity on the other hand. And you know, when you think about law enforcement tools, there's so many tools that law enforcement has not availed themselves of. I know, for example, that many providers of app-based communications want to work with law enforcement. They want to train them, for example, on how to get into your device without having to resort to a passcode breaker or something that would break encryption. There are many tools about the way these devices communicate with each other, the way they communicate with the cloud, that would give access to law enforcement, short of what I would say is a cure worse than the disease. So right now, Charlie, I have to say, I'm not sympathetic to efforts to require and mandate a front door, a back door, call it whatever you want, by app-based communication companies. And I worry that if the United States were to pass such a law, we would just basically see a race to the bottom. All the app-based communications companies would leave the United States, and people would use that foreign-based communication service to communicate, and law enforcement would be no better off.
Let me just briefly stay here with the other two panelists, because this is such an increasingly interesting topic. Bob, do you have a different view, or Glenn? Let's start with Bob. Oh, we seem to have lost Bob. How about you, Glenn? Are you there?
Yes, I am. Yeah, so I broadly agree with Jeremy and feel a lot of sympathy for the sentiments he expressed, but I don't quite go that far. I think there are some cases, some situations where it should be possible to find a technical solution that doesn't increase cybersecurity risk that he was referring to, the risk that somehow whatever solution you come up with is going to make the data even more vulnerable and put privacy at greater risk. Probably there are some limited cases involving data at rest, so to speak, telephones, where it should be possible to come up with a mechanism that only in a very trivial sense increases the actual risk. There are other areas of communications where I agree it's a lot more difficult to come up with a solution that doesn't also increase risk. So I think it's a little more, shall I say, my feeling is a little more nuanced approach to it rather than just simply saying, no, we can't find a solution. I think there are some areas where we can find solutions that may be coupled also with a need for a heightened standard for government, to law enforcement to access this. For example, rather than just mere suspicion or assistance in an investigation, maybe the standard that has to be met to offset the privacy challenge is imminent danger to life or health. My point is not to necessarily go through all the details, but to simply say that I think there's a continuum here, and somewhere on the continuum we can find a solution that doesn't allow child pornographers and other criminals to get away with the evidence, and yet at the same time protects our society, which I certainly understand.
Charlie, can I just mention one thing?
Absolutely. Go ahead, back, Jeremy.
We've lost Bob, but it's funny because the fragility of these app-based communications, and obviously Bob is a casualty here of that, but we'll get him back, is the following. I just think it's sort of really interesting to think about, which is, and Glenn, you know this from your NSA experience, the weight of hacking for many years was about what I would call brute force, basically trying to break into a secure system by breaking their security systems, breaking their encryption. Today, it's really all about vulnerability analysis. And vulnerability analysis is looking at a system, whether it's Zoom or any other system, and saying, what are all the little different ways I can get in? What are all the little different ways I can get in and obtain data? And this is really important because as consumers clamor for featureization, you want your WhatsApp to be able to have a tweet that you forward. So there has to be an integration between WhatsApp and iOS and Twitter. Every time you have a feature that you like, it can capture video, it can capture sound, we can chat in the chat room. Any feature you want, even bringing stability to an app-based platform, introduces a vulnerability. And so there is a lot that law enforcement can do that I don't believe law enforcement necessarily has the technical expertise today. There's technologies they can avail themselves of on the open commercial market to gain access to sensitive communications, utilizing vulnerability analysis, far short of mandating legislatively that companies create a back door or front door.
So Bob is back now and missed some of this. Just to briefly summarize for him and for the audience, I'm seeing a debate here. Jeremy is expressing the point of view more that creating a statutory mandate causes more problems than it would solve, with driving innovation in American companies abroad just to avoid that mandate, and creating systemic risks to bad actors exploiting a mechanism intended only for, let's stipulate, good actors. Glenn seems to have a more nuanced view than purely pro backdoor, in that he thinks that you should be able to, there ought to be a way, I suppose he's saying that just not just normatively, but descriptively, to at least break into, have encryption on devices, data at rest, without creating significant risk of foreign actors getting in. I guess they're not all going to get physical custody of our iPhones. He seems more skeptical that it can be done for real-time communications that is intercepting encrypted data on the web as people are talking to each other. Bob, if you are back and are hearing this, what's your take?
I am back, and I apologize if I say something that has already been said, because I did miss a few minutes of this. But you know, I think there's no question that creating an opportunity for law enforcement access is going to create some risk. I think that's framing the question in the wrong way. We accept risk in a lot of areas because of the social benefit it achieves. Just to give one example, we would lose a lot fewer people every year if automobiles couldn't go faster than 25 miles an hour. But the social cost of that would be significant. When I was in government and I was speaking with tech people and legal people at major internet companies, what they would say was, we know how to solve this problem. It's not insoluble to create opportunities for law enforcement access with a manageable degree of risk. The problem that this is always founded on in their eyes is there's no way we can build it for you and not build it for China as well. And that's, I think, a significant policy issue that the FBI and others have never really addressed head on.
Mm-hmm. All right, well, let me stay with you for a second, Bob. We've been talking mainly about Americans' privacy rights vis-a-vis new technology issues and surveillance, but you just raised the issue of what about bad regimes and using technology for oppressive or repressive purposes. I guess we're, as a panel of former government officials here, we're stipulating that the United States is a good regime. It would never do such a thing, never. But so let's expand our conversation to privacy as a human right, picking up on the seed you just planted, and how American national security practices may affect that, not just in mandating our Silicon Valley tech companies to build mechanisms that a place like China could use for its own ends, but even what the US government is doing directly in terms of gathering foreign intelligence. So the US government position has long been that foreigners have no cognizable privacy rights from a US government perspective. Obviously, the US Constitution does not cover non-citizens who are physically located abroad. But that environment has been changing in recent years, starting with the fallout from the Snowden leaks in 2013, and you were right at the center of that at ODNI at the time. Can you help walk for this, how these issues are in play for this audience?
This is an issue that has been fermenting for a number of years. It starts with I think a basic disconnect between the US and the European legal frameworks, which is that in Europe, privacy, as you said, is viewed as a fundamental human right, and that's enshrined in their legal system. That's not the case in the United States. Privacy is considered an important right, but it doesn't trump everything else in our framework in the way that sometimes it does in the European framework. And so what you had after Snowden's revelation, and more or less the same time when the European Union passed the GDPR, which had significant privacy protections, was you had an effort in Europe to leverage European privacy law against US surveillance activities. And this led to a decision of the European Court of Justice in the Schrems case that basically said that the arrangements by which data could be transferred out of the European Union to the United States were not valid because they hadn't taken adequate account of the scope of US surveillance and the fact that privacy rights were different in the US than they were in Europe. This led to extensive negotiations where I was the representative of the intelligence community, and a new agreement that's called Privacy Shield, which is again under challenge in European courts. But you also see European courts starting to move in this against their own intelligence services. In the last couple of months, the German Constitutional Court has issued a ruling that says that the German intelligence service has to treat foreigners the same as Germans, even when they're conducting surveillance outside of their country. The technological changes that we've been talking about have had a significant impact on this. Because of digitization and cloud storage and internet communications, it's not as easy as it used to be to tell who's a foreigner and who's a citizen, to know where the data is being stored and whose jurisdiction it's under. And these are going to be increasingly complex issues that may have a significant impact on our ability to collect information necessary to protect national security. I mean, if the European Court of Justice next month, when it has an important decision coming down, says US privacy law is inadequate, so no companies can take data out of the European Union and send it to the United States, that's going to have a major commercial impact and lead to significant pressure in this country to try to modify our intelligence collection activities.
That's great. So I have a question here from a member of the audience that also dovetails a bit with something I wanted to circle back with Glenn on. So I'm going to start by reading this question and then sort of segue into the context of what I was interested in and see if you can get you to answer all of it together, Glenn. So this is from Ana Paula dos Santos. She asked, how safe are all the data shared with the national security, national security agencies, lowercase, in an attempt to stop the pandemic? How vulnerable is society in facing all this surveillance? And what are the steps the US government is taking to assure privacy protections? And I wanted to ask you in part about open source data collection techniques for national security. We've been mainly talking here so far about clandestine electronic surveillance, so wiretaps that the target doesn't know about and so forth. But it is the case that the government also gathers intelligence through open sources, the kind of thing that's posted on the web freely for anyone to look at. But the government's using these maybe for different reasons than national security. And an example of that might be, what is the government able to do, what should it be doing, and what shouldn't it be doing in terms of scraping publicly available data to understand what is happening with the pandemic? Glenn, can you address Ana Paula dos Santos' question and this larger issue? Help us walk through the evolving privacy and private sector relations dilemmas raised by open source intelligence collection.
Sure, Charlie. Terrific question, really, in some ways at the core of this Spokes 2020 conference, the issues that are raised there. You know, one of the fascinating things is that some of the earliest warnings of the COVID-19 disease outbreak came not from classified sources, not from government spying on the Chinese Ministry of Health or whatever, but from open source information from social media in Wuhan about increased hospital admissions and people talking on Chinese chat applications about their sick relatives. This information, which is all public, was captured automatically by a bunch of algorithms and programs, one of which some people may know is called Health Map. And some of the earliest indications of this were from public source information, thus revealing how critical it can be to obtain information that affects our national security. So for me, I think the conclusion is really inescapable that for national security purposes, we are going to have to rely more and more on private sector data, publicly available data, and less on old-fashioned government stealing secrets from each other. That will still have a role, of course. And for me, there are three reasons for this. First, weapons and military doctrine is still going to be very important, and our spy agencies are going to need to understand that. But the reality, and we just saw this with a private sector space launch, is that now so much of the technology that's in weapons is actually developed by the private sector and is available in the hands of commercial contractors. So that's not government stealing information from other governments. Secondly, and the pandemic has made this painfully obvious, technology has now made us globally interdependent. from travel to finance to manufacturing to public opinion, public health. What happens in China does not stay in China. The pandemic has clearly, and Jeremy alluded to this in his opening comment, has clearly made us realize that as a definition of national security, we have to have a broader definition than just knowing about North Korean missiles. We need to understand public health issues, supply chain vulnerabilities, economic and financial data around the world, et cetera. So by definition, all of this is public. It may be in the hands of private sector proprietary communications, but it's not government classified information. And then thirdly, the private sector is simply going to have more information, just the sheer quantity of it, more data that will be generated than any government would ever dream of having. With the advent of 5G telephony, the Internet of Things, the increasing role of artificial intelligence, with both relies on and consumes and generates more data, there's going to be an immense amount of data in the private sector's hands that's going to be so much more revealing and thus meaningful than has been previously the case. This data can absolutely enrich and inform our national security operations, but the private sector is largely unregulated in this area. The government, to answer the audience's question, I think does a fairly good job, not perfect by any means, but a fairly good job of safeguarding data that is now publicly available and now put in government repositories. One issue that I think we're going to have to focus on is, while the federal government may have pretty high standards in this area, with a few lapses in the past, but pretty high standards, we're increasingly seeing local police departments, state health departments, et cetera, use cell phone geolocation data, other information to track whereabouts of people in disease outbreaks, and their safeguards may not be the same as what exists at the federal level, so that's certainly an issue. And then finally, let me just simply say that the imbalance between government, which is absolutely and properly quite regulated in this area, versus the private sector, which has an ever-increasing amount of data but is fundamentally unregulated in this area, is an imbalance that we're going to have to address. Also because the private sector has so much valuable data that it makes us more vulnerable due to cybersecurity breaches, which we've seen in medical areas, financial areas, health areas, et cetera. I think the question of how government will be able to access and use private sector data is going to be the defining question for the next decade in this area. And I think that's, of course, obviously what our conference is focused on.
Right. And that connects what you were just saying a minute ago as well about the problems with the phone record, call record detail program, where once rules were imposed on data flowing in from private companies, so it could only be used for one purpose and not another, only be collected if it met one criteria but not another, it turned out to be quite difficult for the government to comply with that. And so an issue that's only going to become more acute for the reasons you identify. Here's a question from Mark Zawillinger. This is taking us back to what Bob was talking about earlier when I was asking him about Fisa, the Fisa bill standoff, and whether the government ought to be able to sit on websites and collect a record of everyone who's visiting that website or typing a certain search term, as opposed to following an individual that they already have suspicions for. Mark Zwillinger says, in your discussion of the standoff on search queries, you didn't mention the Carpenter decision. How should the decision in Carpenter affect the question of whether web browsing history should be available without meeting the hurdles for a physical search under Fisa? And doesn't Carpenter suggest that things like web browsing history should move into the warrant bucket? Bob, could you address, first explain to the audience briefly what is the Carpenter decision and how does that complicate the position you took a few minutes ago?
Yeah, I mean, I think the bottom line in this is nobody really knows where we're going after Carpenter.
But what is
sorry?
What is Carpenter?
Yeah, Carpenter was a decision of the Supreme Court a couple of years ago. If you remember, and I talked about the distinction between metadata and content of communications. And the rationale that was typically applied for saying you don't need a warrant for metadata is what's called the third-party doctrine, that you have exposed information to a third party. When you dialed a telephone, the telephone company saw that that number A was calling number B, and therefore it wasn't kept private, and the government didn't need a warrant to get it. Carpenter involved cell site location information. When you're carrying a cell phone, it's constantly pinging a cell tower, and the cell tower maintains a record of, or the phone company maintains a record of whose phones are in range of what cell tower at what time. And the government, in an investigation of a bank robbery group, obtained a whole lot of cell site location information covering an extended period of time without a warrant, on the grounds that this was the company's data, it wasn't the individual's data, and so the third-party doctrine applied. And the Supreme Court said no. The Supreme Court said you needed a warrant to get this information. What was very unclear was exactly why that was the case. They seemed to feel that if you just get information about one phone on one day, you might not need a warrant, but that the scope of what was obtained here was so great that it violated the right to privacy without a warrant. It's not clear how this is going to apply, whether this is going to undo all of the third-party doctrine, but I do think, as I said before, that our constitutional law on searches and seizures and surveillance now is over half a century old. It was created in a time when people would go into a telephone booth on the street to make a phone call. I think there's going to have to be a substantial relook at how we're going to apply the Fourth Amendment to the current technological environment that we've been discussing this morning.
All right. Well, I think we're running out of time in this hour, and so I'm going to have to let that be the last word. As you can tell just from this conversation, there's myriad issues spinning off of new technology that get into the realm of surveillance, national security, and privacy, private sector, and government activity. We've covered a few of them here. There's others we didn't even touch on, like misinformation on social media websites and whether they're should be considered neutral publishers or editors, and what legal issues might spin off of that, and many other things. But this has been a nice taste and overview of an immensely rich topic, and I'd like to thank all three of the panelists for spending their time with us today, Glenn, Jeremy, and Bob. And with that, Mark, I'll turn it back over to you.
Great, thank you, Charlie, and thank you to all of our speakers. That concludes this session. I'd like to remind everyone that recordings of this and all the other sessions will be made available after the conference concludes. Up next, we will have a privacy leaders panel. I hope that everybody will have an opportunity to register and attend that event, as well as the rest of the events throughout the day today. Thank you all again. Have a wonderful day, and we'll see you at the next session.